Good morning and welcome to our session of the Kansas Court of Appeals. We are on our third case. I'm presiding Judge Catherine Gardner, sitting with Judge Stephen Hill and Judge Leslie Isherwood.
Morning.
We are ready for case number 124378, which is the League of Women Voters of Kansas, Loud Light Kansas Appleseed Center for Law and Justice, Inc., and Topeka Independent Living Resource Center as appellants versus Scott Schwab in his official capacity as Kansas Secretary of State, and Derek Schmidt in his official capacity as Kansas Attorney General as appellees. Counsel, may I have your appearances, please?
Yes, Your Honor. Hal Brewster on behalf of the plaintiff appellants.
Your Honor, Jason Zabadil on behalf of the plaintiff appellants.
Brad Schlossman on behalf of the defendants appellees.
Very good. Mr. Brewster, you may proceed. And my first question is, would you like any time for rebuttal?
Yes, Your Honor. I would like to reserve 3 minutes for rebuttal.
Okay, you may do that. Please go ahead.
And just so I know, Your Honor, I have a clock, but are you keeping time or am I?
Well, I will keep time, and hopefully between the two of us, we'll get it pretty close. So if
Yes,
you
ma'am.
start getting into your rebuttal time, I'll let you know.
Thank you. May I start, Your Honor?
Yes, please do.
Your Honor, may it please this honorable court. I would like to begin today's discussion by reading the text of the statute at issue here today, KSA 25-2438. As of July 1st, 2021, it is now a felony in the state of Kansas to do one of the following three things. First, knowingly represent oneself as an election official. Second, knowingly engaging in conduct that gives the appearance of being an election official. And third, knowingly engaging in conduct that would cause another person to believe a person engaging in such conduct is an election official. Your Honors, these three acts each separately constitute a felony offense, punishable by up to 17 months in prison under the statute that was passed last July. And each severely diminishes the overall quantum of protected speech in the state of Kansas. Your Honors, I don't mean to be hyperbolic, but the civic life of Kansas has, since last July, been ground to a complete standstill. My clients, the Kansas League of Women Voters, Kansas Appleseed, Loud Light, and the Topeka Independent Living Resource Center are the bread and butter, the heart and soul of civic engagement in the state of Kansas. And since July 1st, 2021, their activities have ground to a near standstill. Your Honors, this case boils down to two simple questions. First, does the action of the plaintiffs here violate the plain language of KSA 25-2438? And second, is there a credible threat of prosecution against my clients, the appellants in this case? Your Honor, the answer to both of those questions is simple. Yes. Yes to both of them. My clients' acts violate the plain language of the statute, and there is a credible threat of prosecution. And I'll go into each of those in turn. So let's turn to the statutory interpretation, which Mr. Schlossman correctly says in his briefs is at the heart of the matter. And I agree. So, and we don't always agree. So I think this is the meat of the argument, and I will get into it. So the plaintiffs engage in activities that are plainly violating the plain text of the statute. There are scores of pages of briefing in this case about fancy doctrinal canons of statutory interpretation. And Your Honor, I am prepared to speak to any one of those if you think we need to. But I would submit to you that it is very simple. We need to look only to the plain text that I read at the beginning of this argument. Defendants twice in their briefing agree with my position, with my client's position. And Record Volume 3, page 54, the defendants lay out my argument for me. And I'm just going to read it for you, Your Honor. Defendant states in two separate briefs, quote, if an actor chose not to overtly represent himself as the Secretary of State, but still engaged in conduct that he would cause others to perceive him as the Secretary of State or any other election official, Section A1 would not be implicated, but Sections A2 and A3 might be. Your Honors, I think it's important for me to state the obvious, which is my clients are not challenging A1 of the statute. They are challenging A2 and A3. And that's because the plain language, we are violating it. And it is not out of some intent to deceive the public that the Kansas League of Women Voters is some election official. That is not their intent. But the intent, the mens rea in the statute.
Mr.
Yes, Your
Brewster,
Honor.
if I
Yes,
could interrupt you for just a moment. Since that is not their intent, doesn't the mental state that is required for this provision necessarily insulate your clients from prosecution? Now, I understand that the mental state is knowingly and not specifically intent,
Yes, ma'am.
but knowingly, a person acts knowingly when they are reasonably certain to cause the result. So there is a calculated culpability there. And you have said that is not your client's intent. So I'm struggling to see how it is your clients are at direct risk of prosecution when that is not their intent. And when they specifically notify individuals at these, very popular, very important events that you're conducting, that they are not members of these subject groups. So I'm really struggling to get to that point that you are specifically at risk of prosecution under the plain language of this provision.
Yes, Your Honor. And I think I'm understanding your question to have two subsections, one on mens rea, one on threats of prosecution. May I address them in turn?
Absolutely.
So mens rea, first and foremost, Your Honor has already alluded to KSA 21-5202, which it provides in statutory definitions two separate mens rea, intent and knowingly. The mens rea that is applicable to this statute at issue in this case is knowingly and not intentional, which is a lower grade of mens rea. And let me explain. So under subsection I of 21-5202, persons act knowingly or with knowledge when such person is aware that the nature of the conduct, that certain surrounding circumstances exist, or that his conduct is reasonably certain to cause a particular result. In other words, merely being aware is sufficient, even if it is not the person's goal or desire to bring about the result. And an intentional violation is always a knowing violation, but not vice versa. And to the threat of prosecution, Your Honor, so I will submit to you that Mr. Schlossman, myself, all the lawyers on this case are working diligently to parse this statute, right? My clients, the Kansas League and all the others, are not lawyers. The fact that they are running afoul of this law, so Mr. Schlossman's argument is that we're making this up. There's no threat of prosecution.
Counsel,
Yes,
let me ask you a question about that particular thing. You're making a facial argument concerning this statute. You're saying that this statute is unconstitutional on its face. What difference does it make how many affidavits you have filed by the Attorney General that, oh, we're not going to prosecute you for this? Because isn't your attack on the statute itself and not based on what some prosecutors might, because we have 105 counties, we have 105 prosecutors in this state, and not all of them have signed these affidavits. We're not going to prosecute you. What difference does that make in your attack on this statute, the way it's written?
Absolutely, Judge Hill. So again, I'm hearing two questions. First about threat of prosecution and second about facial attacks. Is it okay if I?
Yes, go ahead. I couldn't hear part of your answer.
First, threat of prosecution. Second, about facial attacks constitutionality. Is that, am I hearing that right?
Yes.
Okay. So first, I would submit to you that we have a valid facial attack on this law, and we have all applications of it are unconstitutional, and it could be struck as facially unconstitutional. However, if your honors do not agree, this is why we brought an overbreadth claim. The overbreadth doctrine, both under federal analogs and under Your Honor, may I proceed? I don't know.
Yes, please do.
Okay.
Thank you.
The overbreadth standard is an exception to the facial challenge rule. And it basically says, and I'm paraphrasing the case law here, but that when protected activity is a significant part of the law's target, and there exists no satisfactory method of severing the law as unconstitutional from its unconstitutional applications. It can be struck as facially unconstitutional. So Judge Hill, that is my answer to your facial challenge. To my credible threat of prosecution question, Your Honor, I would point to the August 2nd press release of the Attorney General, which says he has every intent of prosecuting under this law. If I were you, and I am not, I would ask Mr. Schlossman why he does not address the August 6th press release anywhere in the voluminous briefing. He didn't mention it in the oral arguments before the district judge below. He hasn't mentioned it once in his papers, not in his opposition. His opposition papers were 65 pages, as I count, not once. And that is a key piece of evidence. And I can point to it in the record if Your Honor needs to. But Your Honor also mentioned a very important thing about concurrent jurisdiction. There are indeed 105 DAs in the state of Kansas. Now, one of them, Suzanne Valdez, the DA of Douglas County, specifically has said she is not going to prosecute under this law. And in doing so, she named the Kansas League, my client, by name, because the Kansas League is instrumental in civic life in Douglas County. And not only that, I just need to tell you this because I know two of you at least are KU grads. The other night when KU cut down the nets in New Orleans and there was a party like you've never seen on Mass Street in Lawrence, Loud Lights should have been out there registering voters, and they weren't. They weren't there because they thought they would get prosecuted. And that is in a county where the DA has said she's not going to prosecute because it's unconstitutional.
So,
Your Honor, yes, Your Honor.
My question is very related to this, and I'll bring it up now because it's relating to the standing, which you're addressing through the credible threat of prosecution. But if you assume that the standing test that we apply requires you in this pre-enforcement challenge, First Amendment type of case, to show a substantial threat of future enforcement, and we assume that mere chilling or self-censorship is not enough based on the statutory language, what evidence do you have here of a substantial threat of prosecution?
Again, Your Honor, I don't want to sound like a broken record, but I would point to the August 2nd press release, which is, let me get the record cites for you. It's on.
Yes, I have it. And the last phrase of that says we have concurrent jurisdiction. So law enforcement agencies that get evidence of election crimes may present the results of it to our office for review. We will make a prosecutorial decision based on the facts and law applicable to any individual case.
Yes, sir.
So are you saying that that is a substantial threat to prosecute your clients for doing their normal activities?
Yes, Your Honor, I am. And also, I'll tell you why, because it is true that in unsworn pleading, after unsworn pleading, the Attorney General has said in this case, he's not going to prosecute. But publicly, on August 2nd, he said very loudly to the people of Kansas and every DA that was listening, I'm going to prosecute under this law. Moreover, Your Honor, I am only going to mention two Supreme Court justices by name during this argument, unless you want me to mention someone else. And those are Chief Justice Roberts and Justice Thomas. When there is protected core political speech, as there was in Meyer, as there was in Buckley, as there is in this case, there is no presumption of constitutionality. That presumption falls away, both under federal law and under Kansas analogs. And
so,
once
I'm sorry to interrupt, but are you framing this as a free speech or as a core political speech test?
Your Honor, I think I understand the question, so let me endeavor to answer. And if I am not satisfactory, then of course you will let me know. So I'm sorry, could you rephrase? I don't want to get this wrong, and I'm not fully understanding your question, Your Honor.
Well, I think I understand. Your arguments are arguing that the activities of your clients are core political speech.
Yes, Your Honor.
Okay, thank you.
And I think, the Mr. Schlossman's going to get up here and tell you that you should apply Anderson verdict. And I'm just going to tell you, it is a federal test from federal courts that is motivated by federalism. And moreover, it is about the burden on the right to vote, not the free speech claims that we bring here. Your Honor, it would be as if I were a contract lawyer and asked this court to apply tort law. It just doesn't make any sense. And Mr. Schlossman is a very smart man. He worked for the DOJ voting section. He knows this distinction. And I would suggest that that is a distinction that should be explored on when the other side is arguing. This is clearly at least exacting standard under Myers and Buckley, if not strict scrutiny under the Kansas Constitution. Because again, this case is brought solely under the Kansas Constitution, which is at least as protective as the federal Constitution, if not more so, right? When a fundamental right is at issue, as it is here, and we know this from McKinney, this is the case from the Kansas Supreme Court about free speech. When a fundamental right is implicated, as it is here, strict scrutiny applies. We get that from Hodes and we get that from Farley, both Kansas Supreme Court cases that are binding on this court. And Your Honor, I don't know how much time I have left, but before I sit down before rebuttal, I just want to say, I do not mean to overstate my argument here, but I want to return to the point I made at the beginning. This law is extremely dangerous. I don't need to tell any of you right now that this year is a very consequential year in Kansas elections. You have the primary, you have the ballot measure on the constitutional issue of abortion in August, and then you have a governor up for election. You have all of the constitutional offices of Kansas up for election, not to mention all 4 congressional candidates. If my clients are not allowed to go out and organize and register and engage, this state is going to suffer. And I feel very deeply about this state. During district court arguments, Mr. Schlossman sort of made a crack that I'm from out of town, that I'm a DC lawyer. And I don't mean to curry favor here, but Your Honor, I lived in Kansas for 3 years in my 20s at Fort Riley when I was posted there. I feel very deeply about this state, and I don't want its civic life to diminish. I do not want the overall, to use the legal phrase, the overall quantum of protected speech to be diminished. And that, Your Honor, is why strict scrutiny applies and why this court should reverse the lower court below and issue an immediate injunction now, which you have the power to do. I don't know how much time I have left. I'm happy to.
Well, you're pretty much out of time, but I have a question, and the other judges may as well. So we'll just do that. My question is theoretical, and yet it's also practical. And that is, when we think about the mens rea of this statute, the government would have to prove to find your clients guilty. How does the government prove that your clients acted knowingly when they're not an individual in a criminal case? We're talking about an association of people, the League of Women Voters, for example. Is it done through collective knowledge? And how is, and this ties into the credible threat of prosecution issue, how would they prove your client guilty under this statute?
Your Honor, I believe the prosecution would take place of the individual members of the organizations, not the organizations themselves. However, we still have standing under both associational and organizational standing. Happy to address that, but I think it's fairly covered in our briefs, particularly our reply brief.
Thank you. Any other questions? Judges?
No.
Okay, thank you. We will move on. Mr. Schlossman, you have 15 minutes.
Presiding Judge Gardner, and may it please the court. This case is all about distraction and straw men. Plaintiffs devote nearly 20% of their opening brief to a completely irrelevant discussion and grievance about the legislature's failure to adopt their policy arguments and the failure to give their supporters more opportunities to air their views during the legislative session. They then devote page after page to constitutional free speech and association arguments that ultimately have no bearing here. At bottom, this case presents a prosaic issue of statutory interpretation. If the statute is construed properly and in line with longstanding precedent, then everything else here is little more than noise. Now, plaintiffs ask the court to repudiate firmly entrenched canons of statutory construction, to disregard the court's duty to interpret statutes in a manner that presumes their constitutionality. In fact, our Supreme Court has held that a court has a duty to uphold the statute under attack rather than defeat it if there's any reasonable way to construe that statute as constitutionally valid.
Does that hold true? Does that hold true for cases involving free speech or political speech?
Well, when Judge Hill, when there is issues that involve chilling of speech, then the court relaxes that or I suppose that depending on your terminology, makes it tougher to presume that constitutionality under those kind of statutes. But there is no, in this particular case, there's no chilling. That what the plaintiffs are essentially asking here is for a advisory opinion because they won't take yes for an answer. They want the court to say what defendants have already said, which is what they're doing is not illegal. There is no, I'm sorry if I interrupted you, I'm sorry.
Well, my question is, if you're going to send me to the penitentiary for 17 months and fine me up to $100,000, you've got my interest up. Okay. I don't want to do anything that would put me into jeopardy like that, counsel. That seems to have a chilling effect on me.
Fair enough, Judge. If there was any reasonable interpretation of the statute, what they are proposing is an interpretation, though, that is totally inconsistent with the statutory text and with canons of construction. And
Mr. Shaw, when I read the appellant's brief and reply brief, I see admissions in there from them that they say every time they have one of these voting drives, they've got people that have the impression that they're election officials. And they know that. That seems to me an admission right now in front of all of us that they're in violation of this statute, aren't they?
Judge, Your Honor, I respectfully disagree. What they are doing does not violate the statute. The interpretation that they are taking would obliterate the knowingly requirement in the statute. The knowingly requirement, which my respected colleague cited in 21-5202I, says that a person acts knowingly or with knowledge with respect to a result of such person's conduct when such person is aware that such person's conduct is reasonably certain to cause that result. So it has to be an objective standard. What they are proposing is to interpret the statute that would require a defendant charged under it to be a mind reader and to channel the thoughts of the least sophisticated amongst us. That's just silly. What in fact, they quote on page 16 of their brief, they say that the public's misperceptions of their activities is not going to be common. They say among the literally thousands of Kansans whom plaintiffs regularly interact with, it's inevitable that some will misunderstand the differences between plaintiffs who provide them with these different types of assistance and election officers who do much the same. So in other words, what they're alleging is that if even one eligible and one eggshell naive citizen out there might misunderstand the real role that the plaintiffs and their members play, then the whole statute has to fail. It also sort of ignores the discussion that we've had that I've referenced in our case, that there has to be consciousness of wrongdoing in these cases. I mean, it wouldn't even make sense, their position. And I would also point you, I'll give you the citation, but I would even point you to the US Supreme Court's recent, Justice Kavanaugh's recent concurrence that was decided just 1 month ago on March 7th in Wooden v. United States, 142 Supreme Court 1063, 142 Supreme Court 1063. And Justice Kavanaugh noted this: to be sure, if a federal criminal statute does not contain a willfulness requirement, and if a defendant is prosecuted for violating a legal prohibition or requirement that the defendant honestly was unaware of and reasonably may not have anticipated, unfairness can result because of a lack of fair notice. That scenario could arise with some malum prohibitum federal crimes, for example. But when that fair notice problem arises, one solution, where appropriate, could be to require proof that the defendant was aware that his conduct was unlawful. Another alternative solution could be to allow a mistake of law in certain circumstances. So the court has, I would respectfully submit, an obligation to construe this statute in a manner that is constitutional. What they are proposing, and the other part of it, let me just go back, is that this statute necessarily, in light of the knowingly requirement in 21-5202I, has a objective focus on it.
Let me ask you, I think that's very pertinent to my question. There are 3 subsections to the statute, 1, 2, and 3. The first one, the plaintiffs aren't contesting.
Right.
And the second 2, they are.
Yeah.
Could you explain to me the difference between the conduct for 2 and 3 as opposed to the first?
Yes. So the first one is, I think we talked about this, and I know that Mr. Brewster suggested that we were somehow supporting his position, but I think that's simply not true. Is you could have a situation where an individual was directly trying to, say, impersonate the Secretary of State himself. And that individual then would be in violation of A1. But if you have something that's much more subtle, so you have an individual, for example, who is, let's say, I think a good example might be if you have someone who is, so assume an organization like theirs sends out advance mail ballot applications to voters and tells those voters in that accompanying communication that there is going to be a criminal penalty if they if they do not return it, which is obviously not the case at all. And let's assume that that communication to the voters has all the hallmarks of an official communication. I mean, it's got the county seal, it's got, the name of it's in the upper left-hand corner, it has the name of the county election commissioner and all that. So
how is that different than number one?
Because they're not coming in. I mean, I think that the legislature here was trying to take a subtle view where they see as in A1 as someone coming and actually like to a voting drive and actually saying, yes, I'm Secretary of State Scott Schwab. I mean, could there be a little limited overlap between the two? I mean, I suppose there could. That's hardly fatal to a statute. The legislature wanted to be more clear as to exact type of conduct that's being prescribed here.
And then the third one, I'm very interested in the third one, the appearance.
Yes. So the appearance. So right. So if you have this, again, take my mailing here that I was just describing. So it's got all the hallmarks of the election official of a formal document coming from the county election office. And nowhere in there is there any reference to that, to the private organization that comes from a private organization, and it is and then I guess you could have a slightly more difficult situation is let's say kind of the same thing, but then on page 5, in Lilliputian font, there's some reference that says, hey, this came from the private organization 501c3. So you're not strictly representing yourself as the Secretary of State, but you are engaging in conduct that is going to be, objectively speaking, reasonably certain, again, to use the language of 215202, reasonably certain to cause that person to believe that you are in fact a state or county election official. So this is going to be a tough prosecution. There's no question. And anybody who is to bring a case like that, I mean, it will be an uphill slog, no question, but that does not render the statute fatally unconstitutional.
All right. As I understand it, at these voter registration drives, they use actual cards from the county election office or for people to fill out.
Yes.
I mean, when you register to vote here in Kansas, you fill out this card and turn it in, and it gets recorded.
Yeah.
And so, for example, the League of Women Voters has a stack of these. They go into the election office, they get a stack of the blanks, and they go out and hand them out. That's pretty official, isn't it? It's the official.
But Judge, how is that on an objective basis, again, with respect, making it reasonably certain that the voter is going to, objectively speaking, misconstrue that individual as an election official? I mean, people have been engaged in voter registration drives, encouraging people to get out to vote. They come by my house and give me official ballot applications. I'm not suggesting that there won't be some individuals out there who unreasonably construe the person who is making those kind of registration drives and say, well, gee, as I think one of the plaintiff's representatives said in his affidavit, I know because when I talk to people, no matter how hard I try to disabuse them of this notion that I am not an election official, they simply won't or can't believe it. And I don't dispute that there may be people like that out there, naive individuals, but that from an objective basis does not make it reasonably certain that that individual is that the individual has violated the statute. There's no consciousness of wrongdoing whatsoever. So
But
they simply have not violated the statute.
There could be a prosecution. Could there not?
No, I mean, that would not be consistent with 5202. I mean, look, there are, the Attorney General in this case has expressly disclaimed
Oh,
that.
Yeah, I want to,
Yeah.
your opposing counsel wanted to ask you.
Yeah.
So
Thank
I'll
you.
ask the question
Sure.
about the press release.
Yeah.
You want to talk about
Yeah,
that?
absolutely. I mean, so and I did even, and fortunately I was on the appellee, so I was even able to call it up on my screen here. I mean, the Attorney General issued this press release. First of all, it says nothing. I mean, it's just a general statement that any good prosecutor would make, that prosecutorial decisions will be based on the facts and the law applicable to any individual case. I mean, that is hardly revolutionary. It says nothing about prosecuting a case based on the plaintiff's unreasonable theory of this. And it was simply in response to what I would respectfully submit was a irresponsible statement, reckless statement by a district attorney who decided that she was going to announce, that there wouldn't, I mean, I don't even know why typically you don't see announcements about non-prosecution, but it was, so the district, she announced that under no circumstances was she going to prosecute anything under the statute. And the Attorney General, all he said is that, look, the facts and circumstances control. If someone has a case that they think has been in violation, then they can present it to my office and we'll examine it. I mean, it was sort of a big meow in terms of the significance of it. I mean, frankly, a cynical observer might call the district attorney's comments, intentionally coordinated with the plaintiff's counsel, but it doesn't matter. I mean, all the Attorney General said is that the facts and the law applicable to any individual case are what is his guiding star in terms of making prosecutorial decisions.
Mr. Schlossman?
Yes.
Is there anything, there's nothing in the record, I believe, where we have the Attorney General either saying, I'm not going to apply this law to your client, to the plaintiffs, I mean here, or I will discourage the prosecutors in the state from applying this law in these circumstances, is there?
Well, what we have, I mean, other than the Attorney General's briefing, formal briefing in the case, which represents his official position on the law, I mean, the plaintiffs seem to insist that the Attorney General has to scale the mount and trumpet to the world, his interpretation of every criminal statute on the books. And I don't think there's any merit to that contention. The Attorney General has made clear that the plaintiff's unreasonable interpretation, which focuses on the subjective views of the listener rather than the objective views of the actor, that does not comport with the statutory text or basic logic. And so, I mean, has he issued a formal advisory opinion? No, but that's typically not the role of the Attorney General, or at least a responsible Attorney General. So what I would say.
Yeah, your time's almost up, sir.
Oh, okay, thank you. Well, I will simply say that I think that there is, the plaintiffs have invited the court to wade into the constitutional thicket here. There's no reason to do so. There is, and I won't do so either. I think our briefing, adequately addresses that. But the bottom line is that there is no threat whatsoever to the plaintiffs, let alone an imminent threat, which is what the requirement is under a preliminary injunction motion, the denial of which is why we're here. And I would say that this is, if you look at this statute needs to be evaluated from an objective perspective. Is it reasonably certain from an objective perspective that the conduct that they're engaging in would lead to these kind of individuals misconstruing them? And again, they're the third parties that they're dealing with. Their views need to be viewed from an objective view. The fact that you have an eggshell, innocent, naive, whatever term we want to use, who may be confused, who may be deaf, who improperly, notwithstanding all the plaintiff's efforts to the contrary to disabuse them of that notion, still believes that is not, there's no consciousness of wrongdoing that would not support the basis for a conviction. And there is no reason to strike this statute down on a facial attack. If there's no further questions, then I will turn back my time.
Thank you, counsel.
Thank you.
Mr. Brister, you have 3 minutes. Counsel, I believe you're muted.
I knew that was going to happen. That was my best argument too. You're never going to hear it. So, Your Honors, I heard Mr. Schlossman call the voters of Kansas 3 things during his argument. naive, the least sophisticated among us, and an eggshell plaintiff, which if you went to law school, you know is not a compliment. Your Honor, this is the subjectivity. Mr. Schlossman arguments prove my point. This is so vague. And so he's saying, who are these naive people? Who are the least sophisticated among us that are going to be the ones who trigger this prosecution? Mr. Schlossman, if the tables were turned and the DA of Douglas County, liberal Lawrence, went after a conservative group of college students trying to organize college Republicans, I do wonder if the prosecution would be a little bit different in this case, or if the Attorney General's position would be a little bit different. He mentions formal briefing, that his position is stated in formal briefing. Well, it's not a consent decree. How Derek Schmidt, Attorney General Schmidt, is running for governor. He will not be, win or lose, he will not be the Attorney General in a few months. Someone else will be. And these briefs in this case do not bind that successor, nor do they bind any one of the 105 DAs. And I will just end with two last points, one about constitutional avoidance, which is there is no presumption of constitutional avoidance when a fundamental right is implicated. We have made a prima facie showing of a fundamental right being implicated here. So that constitutional avoidance does not exist. And then I just want to say one last thing, which is Mr. Schlossman went a little ad hominem there and accused me of coordinating with the DA of Douglas County. I will say as an officer of the court, that never happened. So for those reasons, I submit that the district court should be reversed. This court should enjoin the KSA 25-2438 and issue an injunction as quickly as possible in advance of the August primary. Thank you very much.
Thank you to both counsel. We appreciate the good arguments, and we will take the case under advisement and get you a written decision as soon as we can.
Yes, Your Honor.
Court is in recess.